quite well. It was good for me. I always feel a little bit bad because had we not met in the subway, Rabbi Reese would be a multimillionaire living in a penthouse in Manhattan, a partner at Cleary Gottlieb, and well on his way to a Court of Appeals appointment in the Second Circuit. And the CRC doesn't pay that well. That I'm sure of. More than that, I don't know, but the CRC, I'm sure, does not pay what partners at Cleary make. That I'm not sure if I can check on the tax returns, but I'm pretty sure that that's the case. I guess we're going to step back and tell a little bit of the story, because sometimes law takes us in directions that the writers of the statute can't really predict. Justice Cardozo, writing in 1910, tells us that the state of New York should never adjudicate disputes according to any legal system other than New York law, because New York law is true and correct and obviously just, and when confronted with a contract between a railroad that goes from New York to Pennsylvania, Cardozo steadfastly refuses to enforce Pennsylvania law because we all know Pennsylvania law is false and New York law is true. So says Cardozo. And when the second version of this contract said, well, we'll go to arbitration and enforce Pennsylvania law, Cardozo says you can't do that either. There's no arbitration because not only is the law of New York correct, but the courts in the state of New York are God's gift to humanity, and you have to come here as well. Congress, thankfully enough, rejected this approach. And in 1925, almost a century ago, Congress passed the Federal Arbitration Act, which more or less made two crucial points. Congress says as follows: people can enter into contractual arrangements in which they choose a tribunal other than an authorized court, and they can pick a legal system other than the law that seems to at first glance govern our dispute. So when you and I enter into an agreement about the sale of shoes, and we agree that should there be a dispute about the quality of shoes or the payment proffered, our dispute will be resolved according to French law. And it will be heard by a panel only of Italian jurists speaking Polish located in Switzerland. And we both agree to this and we understand it and the agreement is clear. The Congress of the United States has made it clear that that ought to be enforced, and given the fact that we both agree to it, nothing more is needed. This is a contract of arbitration with a choice of law clause, and it ought to be enforced and it ought to be constitutional. At the time, when you look at the Federal Arbitration Act, nobody gave thought to the possibility of this producing Islamic law or Jewish law or canon law, but really, if you think about it, there's no reason why, once we can choose our legal system, that we shouldn't be able to choose religious law. And the Federal Arbitration Act has consistently and regularly been applied to permit religious arbitration. Almost without hesitation or difficulty, the Supreme Court has, for the last 40 years, consistently expanded the scope of the Federal Arbitration Act and has consistently delivered the following basic message. If you sign a contract of arbitration and it has a choice of law clause, you're stuck. Now, of course, here and there, there have been limitations on it. Of course, if it's duress, it doesn't count. And of course, if it's in teeny-weeny, itsy-bitsy little letters that you couldn't read, it doesn't count. And of course, we can't arbitrate things that are not between the two of us, like child custody, because the children didn't sign. But in the big picture, all things are subject to arbitration. And you can pick any legal system you want. And not only that, you can pick a non-legal system as you wish as well. I always ask my law students to consider an arbitration agreement in which we agree to be adjudicated by the UCC with every fifth word deleted. It's very entertaining, but I think that the answer is if we both agree to this, this wouldn't be a problem in any way, shape, or form. And that's the law in the United States. But in the last 10 years, there's been a great deal of conversation about whether this is a good law, and whether we should undertake the kinds of substantive changes that are necessary to restrict arbitration in general, or even more pointedly, to restrict religious arbitration. Or even, if you want to drive it even more pointedly, the movement is led by people who want to restrict Islamic arbitration, because for some reason they're particularly scared of Islamic arbitration as opposed to any other arbitration. And I wrote this book mostly simply to demonstrate that there's a very good defense of religious arbitration in the United States available on a secular level. Most of my works are not secular. This is a secular work. It's designed to talk to people who don't believe that religion is intrinsically good, and they certainly don't believe in one particular religion is intrinsically good. So I want to try to explain to you why religious arbitration is a secularly valuable activity of worth to a liberal Western society that doesn't believe in the correctness of any given faith. Of course, if you're a member of a faith group, it goes without saying that you understand how valuable religious arbitration is, because it allows you to resolve your disputes consistent with your faith rules. But the central question is, that's nice, but what's in it for all of us who don't believe that your faith group is right? If religious arbitration tribunals can't explain the goods that they're delivering on secular terms, they're ultimately going to have a harder time than if they can explain the value of what they're doing on secular terms. Why is this good for everybody? Don't tell me why it's good for me. Explain to me why Western society benefits from having robust religious arbitration. And when you survey the literature, it's worth starting by explaining the case against religious arbitration, because if you understand the critics, then you can begin to formulate the response. The first criticism, which is in the biggest of pictures, the French criticism, goes as follows: one law for one people. France and one province in Canada already simply does not permit substantive religious arbitration, and when you press France on it, they more or less say as follows: everybody in France needs to obey French law, one law for one people, and allowing people to contract out of the law of our society is disruptive of the unity of the people. More or less in France, you can't opt out of French law unless one of you is a citizen of another nation or it's a multinational corporation. But when you and I get divorced, we get married in France and divorced in France, and we're both French, French law applies because it's one law for one people. It builds community. This argument says to insist on the uniformity of law. We'll come to a response to this because it's a very important American response to this that reflects on values. More importantly, the argument goes that if you let people opt out of your legal system, religious arbitration produces substantive injustice, i.e., religious communities have bad rules. And if you let people sign on to the bad rules, you know what you'll end up with? Bad outcomes. And that if you stop and look at the substantive religious rules at play here and there, what you see is that a diversity of religious rules that secular people say this is repulsive to us, starting with the idea that only one gender can grant the other a bill of divorce, or a variety of other things that a secular person might look at Jewish law or Islamic law or canon law or a variety of other provisions and say this is not the right way for civilized people to conduct themselves. Related to this, a kissing cousin, to pick a peculiar term, is this idea that religious arbitration produces procedural injustice, which is even if the substantive law is correct, when you attend religious tribunals, you see an inability or an unwillingness to engage in procedurally proper behavior. It's certainly true if you meandered your way through the New York State decisions on rabbinical courts, you will occasionally find gross examples of procedural misconduct. There's no doubt at all that that is correct. There's some truth to the fact that, at least in times of old and in places long gone, rabbinical courts, and to this day Sharia courts, it sometimes engage in procedural malpractice. And there's something to be said in preventing procedural injustice. Courts have procedural rules that they want arbitration panels to follow, and not allowing them to hear cases in which there is procedural injustice is important. Somehow related to this, but not exactly, goes as follows. Allowing people to sign arbitration agreements entrenches the hierarchical religious structure that secular people so much do not like. And that if you allow people to sign arbitration agreements, what happens is you build communities grounded in a hierarchy. And this hierarchy entrenches the hierarchy. And those of us who are liberal Protestant, who believe in non-hierarchical religions, want to do things that undermine the hierarchy, and religious arbitration is the exact opposite of such. And its close cousin in that situation, of course, is the same thing, which is secular communities have a really hard time policing religious arbitration because they tend to be small, insular, hierarchical communities, and when an injustice occurs, it's awfully hard to investigate them. All of these are, at some level, somewhat valid criticisms, and working in the background of this, of course, is the most basic claim, which is dragging somebody to a religious arbitration tribunal violates their religious freedom rights by compelling them to go to arbitration when at this very moment they don't want to go to arbitration. That there's some sort of establishment clause problem enforcing a contractually agreed to religious arbitration. And the broadest critique is, of course, as follows. Allowing religious arbitration promotes isolation and encourages religious communities to look at themselves rather than look around. And that it encourages this kind of robust insular community, and it doesn't allow religious communities to benefit from the breadth and the depth of what's actually going on in the United States. This is a fast picture of the criticisms of religious arbitration. But I guess I want to go to the response much more intensely because it explains why I think religious arbitration is a secular good rather than a secular bad. The first and most important is recognizing religious communal rights, and not just religious individual rights, is a First Amendment imperative. When you say to people, you can do anything within your community, but you can't bind yourself to doing it, it substantially undermines the ability of a community to form itself consistent with its religious models. Religion is not just me and my God, it's frequently me and my community. And if you incessantly cut the communal bonds so that it becomes impossible to form freely entered into religious associations, what happens is that religious community disappears. The death of religious community has profound systemic implications for lots of other parts in America. Most charity is religious. Most food banks are religious. Religious communities tend to give more, not just to their own, but to everybody. If you destroy religious communities, then you end up with destroyed religious communities. This is no novel insight. What creates community is reciprocal obligation. And this reciprocal obligation is centrally supported by arbitration agreements, whether it's in the context of marriage, or it's in the context of commerce, or it's in the context of inheritance rules. Religious communities are a way of building structure. Having these points of light, to use President Bush's phrase, enlightens society. And it's easy to say, well, can't people do this on their own and in voluntary ways? But the answer frequently is not, which is the reason why I want to do what I want to do is because you've agreed to do what you want, what you're going to do, and I'm acting based on your assurance. And I want assurances that after I do what I'm doing, you're going to do what you're doing. The second observation is equally important. Religious arbitration better resolves certain kinds of disputes. Co-religionist commerce, to use the phrase that Professor Michael Helfand of Pepperdine uses, is a very important subfield of commerce. The simple fact is that, of course, federal courts can determine whether the meat is adequately kosher, so that when I promise to sell you kosher meat, and you say this meat isn't kosher, in some theory level, there's no First Amendment problem with federal courts determining whether you adhere to the contract. But the truth is that it's very hard for secular courts to look at co-religionist commerce with their own phrases and preconceived notions and correctly determine the truth of what the parties intended. Co-religionist commerce is hard to understand within the Jewish community, within the Islamic community, within the Christian community. In each of these communities, words have idiosyncratic phrases and meanings. And insiders know easier and better what those terms really mean, and they do a more accurate job of adjudicating disputes. That's why lots of communities have moved to arbitration. This isn't just about Judaism or Christianity or Islam. It's about the fact that the diamond merchants have a diamond merchants court, as Barak Richmond of Duke points out. It's because diamonds are hard to classify. Very, very, very specific knowledge is needed. And when I agree to sell you a diamond of a particular grade, I know what it means because I'm a diamond merchant, and you know what it means because you're a diamond merchant. And a federal judge can probably learn what it means after spending 3 years of his life taking the appropriate courses. But it seems so much easier to have diamond disputes resolved by the diamond courts. If you think diamonds are hard, Judaism is harder. It's just true. If you think diamonds are hard, saying to you this meat is kosher, or this pair of tefillin, phylacteries are valid, or any other particular activity. And I'm sure, by the way, that this is not just unique to Judaism. It's not that we're complicated, but every other religion is simple. I'm sure every religion says understanding who we are takes a many-year course. And when you tell a federal judge, read the briefs and decide, it increases the likelihood that co-religionist commerce is resolved incorrectly. Not just in Judaism. I serve as an advisor to 2 evangelical Christian courts in the Southeast. It makes my mother proud that I serve as an advisor to 2 evangelical Christian courts and 1 Muslim court in the Southeast. It's sort of always fascinating. And they come with the same problems. It's the same thing. Words have very specific meanings within religious cultures. And it's hard to explain them to other people on the outside, even though, of course, everybody in the community knows what it means. Co-religionist commerce is, simply put, hard to resolve. And related to this is that certain kinds of problems simply can't be resolved because the religious community immunizes itself from judicial interference. The classical example of this, from my perspective, is the Jewish divorce problem. When a secular court judge orders a husband to give his wife a get, according to Jewish law, under threat of incarceration, the husband promptly says to the judge, what? I'm happy to give the get. I don't wish to go to jail. That's what almost everybody says. When a federal judge says it, or a state court judge says, if you don't do like I'm telling you, you're going to go to jail. Most of us say, tell me what to do, Your Honor. And the judge says, head down to the rabbinical court and tell them you must give a get or you're going to jail. Which the man promptly heads down to do. And what does the rabbinical court say? They say, oh, now we will not give the bill of divorce because we will not give a bill of divorce when it's coerced through secular courts. There are varieties of religious problems in every faith that cannot be solved outside of religious arbitration. Chicago not only has a rabbinical court, it has a sitting canon law court that resolves questions of canon law. And if you think that the canon law courts will recognize as valid canon law resolutions put forward by the trial court in the state of Illinois, you are mistaken. They are no different than the Jewish law courts. They say certain disputes cannot be resolved in secular court. Most religions adopt this view. There are a variety of religious problems found in religious communities where the faith says, if you head to secular court to resolve this dispute, your resolution is a nullity. A husband who's told by a state court judge that he must issue a get or he will be incarcerated, no get can be given. On the other hand, when a rabbinical court orders a Jewish divorce to be given, even if coercion is present, such a divorce is valid. And by the way, again, it's important to understand, this is not a Jewish problem. This is true in canon law as well. There are a variety of church property disputes that can only be resolved by canon law courts, and they treat secular pronouncements as a nullity, just as a nullity. No different than the classical phrase in the Mishnah from close to 2,000 years ago, which says coercion by a non-Jewish court to give a bill of divorce is a nullity. A similar statement is found in the canon law with regard to church property disputes resolved in secular court. They are simply a nullity. But then when you move on to a little bit of public policy, what you see is something else that's very important. Here's the truth. Secular recognition of religious arbitration helps moderate and integrate religious tribunals in many subtle and nuanced ways. If you look at the wonderful rules of the Chicago Rabbinical Council, you see in them not just Jewish law, you see in them the hand of secular arbitration law. Things are there that are not required or even recommended by Jewish law. They're there reflecting the moderation and integration with secular society. Religious tribunals want their pronouncements to be recognized by the secular courts, and to do so they are prepared to moderate and temper religious doctrines consistent with their faith, but nonetheless moderate and temper them in order to achieve secular recognition. Secular society, through its legal system, moderates religious communities by holding out recognition. If you conduct yourself consistent with our notions of procedural due process, your decisions will be recognized. These are moderating influences. If you acknowledge that you have no coercion rights, your decisions will be recognized. Jewish law intrinsically might imagine a situation where a rabbinical court could order somebody to be hit, but not a rabbinical court that wants to have its decisions recognized. A canon law court still has the theoretical ability to order people burned at the stake, but not in Chicago. It's important to understand that religious arbitration profoundly holds out the possibility of moderation. And I want to share something even more important. The moderation goes both ways. I've made countless appearances in front of judges in my rabbinical capacity, and they say, "Oh, what do you do?" And I say, "Well, I'm a law professor at Emory." It gives the interaction between religion and the secular court system isn't only that secular court systems moderate religion. Religion gets to share a vision of itself with secular court that's moderate, normal, reasonable, cohesive, coherent. It's important to understand this. If you write child custody decisions in a rabbinical court, you know they're going to be reviewed by a secular court judge, and you write them carefully and thoughtfully in a way that's designed to impress the secular court judge with your ability to do this. It's so important to understand that religious arbitration moderates and integrates religion, and that moderation and integration of religion not only enriches and integrates religion, it enriches and integrates secular society. The river goes both ways. It's so important to understand. I teach in a law and religion center at Emory, and I work not only on the influences law has on religion, but I work on the influences religion has on law. Grand religious traditions share their values with secular legal communities, and judges look at them and say, gee, that's very interesting. Maybe that would be something good to think about. The natural discourse that occurs between thoughtful rabbinical courts and thoughtful secular courts is itself enlivening not just of the Jewish tradition, but it's enlivening of the secular tradition as well. As Watson, in his famous book about legal transplants, makes note, lots of legal transplants have occurred from religious legal systems to secular law. It's too easy to think that religious legal systems are moderated and tempered and enriched by their interactions with the common law, as if the common law is the big brother that has everything to teach us, and we have nothing of value, all we need to do is learn. But the truth is, it's very bidirectional. Religious communities teach values and teach legal principles to secular communities, just like secular communities teach legal principles and legal values to religious communities. The river flows upstream and downstream as well. It's hard to even know which way is up and which way is down sometimes. That enormous interaction is enlivening of public policy and adds something to the United States. It's not just that it adds something to religious communities to interact with secular values. The interaction between secular society and religious values leaves secular society simultaneously enriched. If you instead create rigid walls in which secular communities are over here and religious communities are over there, the value sharing that builds this healthy respect, this sharing, this allowing of common values to permeate and to recognize legitimate differences. Sometimes all that you really want is a recognition of the fact that what we have here are differences. And maybe what you get from this kind of process is a recognition of the fact that the other will remain the other, but I will have a healthier respect for the values that the other has. The heart of dismissing the other is to start by saying the values they contribute to our society as a whole are worthless. If you say that religious community is worthless and has nothing to contribute, it becomes so much easier for secular people to dismiss their values. The integration that takes place from religious arbitration dramatically has the possibility, and we've seen it many times, enhancing religious values. Anybody who's looked at the death penalty discussion or bioethics sees that religious values play an enormous role in many public policy discussions. It's not just that religious communities are enlivened by the federal rules of civil procedure. It's that secular society is enlivened very much by the presence of religious communities. On the whole, what you see here is a stronger case from a secular perspective favoring religious arbitration. Religious arbitration makes Western society better. And let me add, it's grown even better once we acknowledge that the United States is itself a diverse place. The one law for one people argument never held water in the United States. We are, at any given moment, living in jurisdictions that have multiple laws. You obey the laws of Chicago, and the laws of Illinois, and the laws of the United States. And if you move a few miles away, you'll find yourself in Indiana with a different law. We've never been France in the United States, with its rigid belief of one law for one people. The joy in the United States of federalism is it allows a diversity of legal expressions. As Brandeis famously said, it allows experimentation between the states. All you have to do is recognize that religious legal systems is another form of that vibrant experimentation. It allows people to adhere to yet another legal system. You not only have to obey the law of the United States, and you not only have to obey the law of the state of Illinois, and you not only have to obey the law in Chicago, but you obey Jewish law as well. And that idea, which is you can pick the legal system that you want to obey, not just by moving from Chicago if you wish, but by self-adherence through contract law, dramatically expands our vision of what's going on in arbitration. And, much more importantly, in a diverse multicultural society in which one single ideal no longer dominates. America has moved away from a majority religion. Just that realization. I see this all the time in the South. The evangelicals 20 years ago thought they owned society. And now it turns out they don't. So what do? You have to retreat and build your own legal system. The Jewish tradition never even aspired to own society. We've always wished to govern ourselves by contract. And the rise of contract as a very fundamental principle of liberty allows us to recognize that you and I ought to be able to formulate our wishes and desires in a way that we both agree to, and that forms part of the federalized legal system that governs us. Will not only be governed by the law of the United States, and will not only be governed by the law of Illinois, and will not only be governed by the law of Chicago, but will be governed as well by Jewish law. And the reason why Jewish law will govern us is not because it's intrinsically right, it's because we agreed to it by contract. And contract then becomes a basic model of liberty. If we don't have undergirded principles that we all agree to, because we're a diverse, pluralistic society, the only undergirded principle that can really sew us together is this idea that when you and I agree on what should govern us, it ought to, in fact, govern us, and nothing more and nothing less. And, of course, it can't be infinite, and we all recognize certain limitations, and we can put forward coherent models for what these limitations ought to look like. You can't hear criminal matters, almost because by definition, criminal matters don't entail consent. Sometimes civil matters, like bankruptcy, because by definition we're adjudicating group rights where my adjudication of my rights to you dramatically impact on my rights to other people. We can't have rabbinical courts hearing claims between one creditor and one debtor in a bankruptcy situation because by definition the debtor doesn't have enough assets to pay off all the creditor. If he pays off one creditor, there'll be a shortage of assets in another creditor. And of course we have to have some basic limitations. The most basic limitations are we need to make sure arbitration agreements are truly voluntary. A society needs to invest time, effort, and energy to verify that when people sign arbitration agreements, they do so voluntarily and of their own free will. No coercion. But I need to add something. The assertion that if you can't be a member in good standing of my community unless you agree to this arbitration, that is not coercion. That's associational rights. When I say everybody in my church signs binding arbitration agreements, and if you won't sign one, you can't be a member of my church, that is somewhat coercive because you want to be a member. But we have to grant religious communities the associational rights to form their communities as they see fit. Those of you who are interested in seeing the litigation about this, there was vast litigations 30 years ago about the Hutterite brother communes in North Dakota, where more or less when you joined a Hutterite brother commune, you agreed that you could leave whenever you want, but all your assets were forfeited when you left. And the courts enforced that because you're allowed to say these are the associational norms in my community, and you don't have to sign them, but you can't join my community and refuse to obey our norms. Of course, related to this is we have to make sure there's no arbitration on criminal matters. So we recognize that that which got Rabbi Mendel Epstein sent to jail ought to not be permissible. You cannot go to a rabbinical court hearing in which a party is not present, have the rabbinical court authorize tasing the husband because he hasn't given a Jewish divorce and tase him. And rabbinical courts simply cannot engage in activity that are commonly defined as criminal in our society, and really they can't adjudicate allegations of criminal impropriety as well. Rabbinical courts, with a great deal of hesitation, should stay away from things that in a different setting would widely be considered a crime. And maybe every once in a while you could even imagine religiously neutral public policy conversations that rabbinical courts could stay away from, like maybe copyright and patent infringement, in which even though we seem to be adjudicating just our bilateral rights, actually the underlying issue could very well be, is the patent valid? And the validity of a patent can't be adjudicated in a reasonable res judicata way between this plaintiff and this defendant, even by an extremely competent rabbinical court. When the patent office says this patent is invalid, it would seem unwise and violative of public policy for a rabbinical court to say, no, we think this patent is valid between these two parties. You could construct that maybe there'd be cases where that could be permissible, but you could well understand Congress's decision not to allow patent disputes to be subject to arbitration. By the way, that's not the law anymore. Congress now allows patent disputes to be subject to arbitration, but you could imagine areas of law, and it used to be true in patent, that some disputes, like patent disputes, could not be resolved due to arbitration. And the most important limitation, of course, is that secular courts have to void religious arbitration hearings that don't adhere to procedural due process or generally accepted theories of justice. Everybody knows, and if you read the New York State reporters, you occasionally encounter egregious cases. Rabbinical court judges are hearing matters where they profess neutrality, but have actually taken a loan from one of the parties. Or religious arbitrators have professed neutrality, but one of the parties has profoundly contributed to the religious institution owned by one of them. Of course, secular courts have an important role here in policing procedural due process. Of course they do. Without it, there's always a worry of corruption or hidden bias. Corruption and hidden bias. And by the way, these are not uniquely true in rabbinical arbitration or canon law arbitration. These are problems in any society. Judges sometimes take bribes. That's a very bad thing. Not just perhaps maybe judges in rabbinical courts, but everywhere and anywhere. The purpose of the court system has to be to patrol against judicial corruption by state court judges, by arbitrators, by almost anybody who professes neutrality. Procedural due process is the bailiwick of arbitration enforcement. But it's also important that secular courts not be too blindsided. States sometimes have rules which say no hearings on Sunday, which I guess makes sense in a secular court context, but it makes almost no sense in a rabbinical court context. It just doesn't make any sense. Rabbinical court context, the proceedings should say no hearings on Saturday. And in Islamic court context, it should say no hearings on Friday. So it's important for judges to apply procedural due process in context rather than out of context. And if they're too literal in their procedural due process, what happens is a sense of wholesale taking from secular court norms to religious court norms where really, in fact, no procedural protections are actually granted. So it's important to have procedural protections. It's important to recognize that not every single procedural protection granted in secular court needs necessarily to be granted in rabbinical courts or Islamic courts or canon law courts. So the state of Georgia has a rule. The rule says no court hearings on federal holidays. I like that rule. If I were a lawyer, it would probably offend me very much if a judge had hearings on New Year's Day. There's a rule. It says no hearings on New Year's Day. It's a federal holiday other than true emergencies. But it's not obvious that you want to apply the rule against hearings on Christmas to rabbinical courts. It's far from obvious. Maybe rabbinical courts hear things on Christmas because it's a convenient day for the parties. How come? They don't go to work. They don't go to work. And yet, even though they don't go to work, what else don't they do? They're not giving out presents to their children. It's a convenient day in the Jewish community to engage in certain activities because it's both not a work day, but not a celebrated holiday in the Jewish community. Why shouldn't there be arbitrations on Christmas Day? I understand why there aren't federal court hearings or state court hearings, but it's not obvious that you want to grab every single procedural protection and closely apply them. And related to this, of course, is the rule, which is if religious arbitration tribunals want to succeed, it's because they're going to be headed by people like Rabbi Reitz, who not only is a well-trained rabbi, but a well-trained lawyer as well. It doesn't work when the religious arbitrators are totally unfamiliar with the norms of secular law. One of the interesting things I see now in my position at Emory is I see many more well-trained Muslims and Christian clergy going to law school, and you ask them, what are they doing here? They're saying, you know what, I want to establish, I want to bring the wisdom of secular norms back into my religious community in ways that I think ultimately is what I did 30 years ago and what Rabbi Reitz did 30 years ago. This model is very important. When you take well-trained clergy and send them to law school and then send them back into doing religious arbitration, they don't just totally forget about the secular law that they learned. It creates better models of religious arbitration, more attuned to the norms of secular society. And then, of course, the biggest change here is America is changing. We've gone from a society where we have a dominant culture. We don't have a dominant culture anymore, or to the extent we have a dominant culture, it's secular. And Christianity, or even its close cousin, a word I don't particularly like, the Judeo-Christian ethic. The reason why I don't like it is because I don't know what it means. I don't know what exactly is part of the Judeo-Christian ethic, but to the extent there was a common ethic in the 50s, that common Judeo-Christian ethic of the 50s is long gone and over. The rules of conduct that my mother taught me and my father taught me are no longer the social rules of conduct, not even obeyed by the president in office. Sort of the norms are not the case anymore. We're living in a different society in which there isn't a dominant ethic. in our society. So the question becomes, in a place in which there is no dominant Judeo-Christian ethic, how do we thrive? And the answer is we thrive by recognizing that people ought to have the right to engage in contractually agreed upon arbitration of matters that affect their society. And I'm putting forward, by the way, an even bigger claim. Cultural wars are historically resolved in the United States by the winner stomping out the loser. And here's the truth. Nobody really likes to be stomped out. I'm proposing a different resolution of the cultural war. I'm proposing that we recognize that different subcultures exist, and they ought to be allowed to thrive and prosper and legislate and regulate their own through religious arbitration. If we allow religious arbitration and we don't insist that secular law is the one and only true law, then different subcultures will thrive. And the cultural war will end not by the winners stomping out the losers, but by everybody winning. And religious arbitration is an essential part of that peaceful tranquility. If we don't allow that, we're doomed for another 20 years of cultural war. The winners will win, the losers will get stomped on, but those who are stomped on will rise again. Because when you're stomped on mightily, you don't just say, I lost and I'll go away. You say to yourself, I will retreat until I am strong enough to vanquish the victors. I don't want to live in a society in perpetual cultural war. I want to live in a society in which I'm free to live in my culture as I see fit, with arbitration agreements that enforce my rights against people who sign them. And you should feel free to do the same. We will each formulate our own culture as we see fit. It will be the multicultural salad, in which the tomatoes hang out with the tomatoes, the cucumbers with the cucumbers, and the lettuce with the lettuce, rather than the melting pot in which we're all forced to conform to one social norm. Thank you all very much. I welcome questions. Please.